My Lord Mabirizi, I am the applicant, appearing in person. I thought the recording system, the recording people may. My Lord, there is a joint scheduling memorandum, but we will seek for indulgence. This morning, we have agreed with the respondents to change their case by deleting paragraphs 8 to 13 under respondent's case.
Is that the position?
My Lord, is the position. The position substituted the argument to agree with the counsel of the applicant.
You are adding other arguments.
We are substituting just the ones we didn't reject, we have substituted them. And
So you have another document?
Yes, we have another document precisely.
So how are we going to have the misstating if we don't have?
We do have it, my Lord, we have shared it.
My Lord,
Have you changed?
my proposal is a standard. And we need to print it. That's why I'm applying for a standover.
You change the thing and then you make us sit here and then you say you want to proceed. You made us sit somewhere for you to go and change your things.
My Lord,
Come with the documents. We should have come and told the clerks that we are substituting the scheduling memorandum. Now we are sitting here and you are telling us, when you are sitting with the in fact document.
my Lord, if I may.
First, tell us why you do that.
My Lord, we may apologize that we have done this. The reason was, when you look at the respondent's case, I objected to those paragraphs 8 to 12, actually to 13, because they included matters which were not in their pleadings. They were referring to a decision in High Court of Uganda which was not part of their pleadings. So my objection to them was that they cannot include matters which were not pleaded. So they agreed, and here we made another document. That's why I was praying for a short adjournment so that we print the document, we share it with court, then we come back and finish the conferencing. There was a delay, of course, because we did not meet yesterday. We have met here, and that's what we have agreed upon. It's not an intentional thing that we wanted to waste court's time. My Lord, sir, amending their response is different from including matters in a scheduling memorandum which are not in their response. Even the amendment will be prohibited because these are facts which happened after filing and outside the 60 days in my course of action. My opinion was maybe it could be an authority in their submissions, but not as part of their case. Because from 8 to 13.
Other than the deletion of 8
to 13.
13.
Yes.
What else has been changed?
Nothing.
My Lord, we have not changed anything. The substitution is just trying to confirm what the respondents averred or contained in their response. The appointment, approval, and swearing in of the Chief Justice, Deputy Chief Justice, was done in accordance with the law and does not contravene the treaty. That precisely that is our case. That's what we have reproduced from our response into the joint scheduling memorandum. We are coming to the issue that we had brought on paragraph 8. We shall bring that one. We shall ask court to take judicial notice of that decision in our submissions. We find it not progressing us.
So number 8 to 13. For example, what's wrong with number 13?
My Lord, number 13 has roots from 8 to 12. It's a conclusion to say that this court is bound to respect and comply with the decision they have cited in number 8. They actually, it's as if they're impugning this court, yet actually what is being impugned are actions of the respondent. They are saying this court must follow that decision. That's how I understood it. Is
this court compliance with the treaty matter for offshore positions?
No.
Because this is Scotland. This is nothing being said here. It's just saying this court is obliged to comply with the law.
That's a better word.
So is that a respondent's case, or is a statement of the law which is there?
That's why we are saying it should be removed.
I think it would have been very helpful for us if you people had come with a proposed replacement of 813, because now we're discussing abstract.
The lower court at paragraph 123 again made another abnormal finding that for purposes of standard of proof in the present case, or standard of proof, it is that
abnormal or erroneous?
It goes beyond erroneous. It is so abnormal, in my opinion, because the judges are saying, for purposes of standard of proof in the present case, is that the fully conclusive evidence required of challenges of apex court judicial decisions should demonstrate a clear and notorious injustice, visible to put it thus a mere glance. And at page 32, paragraph 249, they said, the reasons underlying the majority justice decisions and or indeed the decisions themselves cannot be suggested to depict a clear and notorious injustice that is visible at a mere glance. This is the standard of proof they are putting in a civil matter, where the treaty only says, just prove there was unlawfulness, there was breach of the treaty. The court is saying, I must demonstrate something, I don't know, fully conclusive evidence. This was a standard which is not applicable to this matter. And wherever they picked it from, the facts were actually different. Those things involved. Actually, the court contradicted this decision in application number 9 2018. That is Basajja Balaba and another. At paragraph 3 of that decision, the law facility division held that the decisions or actions of the domestic courts may be interrogated to determine their compliance with express provisions of the treaty. Now, this is the standard. We interrogate the compliance. Now, in my case, they change. They take the Supreme Court of Uganda, they give it a little higher rank, that for it to be interrogated, I need something higher than, for example, if I'm interrogating the actions of the police of Uganda Revenue Authority. Yet actually all organs are equal international law. I can impute their conduct. My lords, you look at I had discussed when my time was reduced from 4 to 10 minutes in the Supreme Court. The land judges upheld that without any serious reasoning, because what is rule of land fairness? If you agree, we agree. You don't come then disadvantage me. Then the lower court confused my December 2020 recuse application, because somewhere it said that I did not raise the objections against the judges in the lower court. That's why they said I should keep quiet for permanently. But now they confused my point. I will refer you, my lords, to paragraph 205 of my affidavit in support of the reference, at page 96 of the volume. I said that I was not able to lay the above information relating the past and current friendship and relationship of Katrebe CJ, Aracha Amoko, and Tumwe CJ with General Kakuta Museveni, because before hearing, during hearing, and in defense of the judgment, I was not in possession of the above stated information. So, this was evidence on record when I said I was not in possession. But court is saying I was in possession and I kept quiet. in disregard of this evidence, I will refer you, my lords, to Appeal number 2, 2019, Republic of Uganda versus Secretary General, where this court had held at page 32, paragraph 32 that a court commits an error of law when it misapprehends the nature, quality, and substance of the evidence, wrong inferences from the proven facts. This is what happened. That they misconstrued my case against the judges. These are matters I did not know. When they came to my notes, I mentioned them. I now move on to the finding at page 3228 to 29 of volume 8, that's the judgment. That past political affiliations, education or service background. The judges said that political affiliations don't matter, the past. My lord, I argue time back in issue number 2. Now we're on number 3, the substance. I argued burden of proof, I argued the standard of proof. I've argued now, I'm now arguing how I'm putting out some aspects which need highlight where this court actually made errors. I've talked about confusing the evidence I presented. Now I'm talking about the finding at page 3228 about past political affiliations. The court relied on the commentary on to the Bangalore's principles of judicial conduct to find that the past political affiliations do not matter. But the same commentary, I refer you to paragraph 89 of the commentary. The commentary to Bangalore principles states that, first of all, paragraph 88 says, any responsibilities and interest that the judge my lord, I think I pray for maybe 10 minutes since there was some. No, 5. Okay. So I was saying that when you look at paragraph 89 of the Bangalore principles, they say, however, these general observations depend on the circumstance of a particular case and on the case before the judges. So had the judges looked at the evidence before me, I mean before them, they would have found that actually these are serious political affiliations, being a member of a political party, being a personal friend. Then I move on to discriminating me on account of being self-presented. This discrimination was a little bit wider. For example, when they talk about legal profession, yet I never came to this court as a legal profession. I came here as a party. Then the judicial fraud. This court refused abdicated jurisdiction to determine the judicial fraud in Uganda Supreme Court. I made it clear that my win was not declared. The judges said I should take back the matter to Supreme Court. Yet this was something clear. You look at the case of Chalimpa versus Attorney General. Then I'll go to condemning me to costs. When this court was condemning me to costs, they said that because I'm a lawyer, I should pay the costs. That reasoning is at page 389. My lord, that's not the principle of condemning people to costs. And actually, contrary to the finding that I had no difficulty, when you look at page 3406 of volume M of my reference, I told the lower court that, my lord, this case I've come here after fundraising from them. It's on record that I had financial difficulties. But the court is saying I'm a lawyer, I didn't have financial difficulties. Then, my lord, I refer you to a decision which showed that this court was, the lower court applied double standards. The Republic, the case is called Salim Abe. Rashid Salim Abe versus Attorney General of Tanzania, reference number 9 of 2016. This was a frivolous reference challenging the Union of Tanzania and Zanzibar. the court never awarded costs. But in a matter where I even succeeded on some points, the court is economing to costs. My Lord, I will first refer you to the decision of Dabule and Union Trade Center to surely find that there was no justification to condemn me to costs because this was a clear case. In conclusion, my prayer is a de novo hearing. That's the principal prayer. You order a de novo hearing. That's the decision in Dabule and the Union Trade Center because justice was not done. There are many procedural irregularities. In alternative, I maintain the prayers in the memorandum of appeal, both in the main and alternative.
Thank you, Mr. Mabirizi, for taking time. Attorney General of Uganda, 30 minutes.
So, of the record, this court determined the matter of Supreme Court initiating issues, which was at page 2234, page 3244 of the judgment. I didn't quote the paragraph here, but at that page, the lower court is discussing my argument that the Supreme Court had in law initiating its own issues, which were not part of the case. But this thing had happened on 13th November 2018. It was done almost 6 months before the judgment. The court determined it. Yet, when it reaches others, it refuses. At page 3244 again, we had an argument of validation of respondent submissions. The Supreme Court validated them without my input. And the court determined it in favor of the respondent. But this action had happened on 9th January, outside the 60 days. When you look at page 2175, on changing rejoinder time, at conference in Supreme Court, we agreed that I will rejoin within 40 minutes. The Supreme Court made a return and told me 10 minutes. The lower court said it was okay. But this is something which had happened on 6th January. So in the judgment itself, the court is having double standards as to those facts which happened. Therefore, it beats my understanding why the court chose what actions to determine and not to determine. If indeed they believed in what they ruled against me, that everything 60 days after 18th April must be time-barred, because this was a band of the facts. So I pray that you answer issue 2 in affirmative. I'll proceed to issue number 3. Whether the first instance vision of the Supreme Court of Justice had in law in determining that the process and decision in question appeal number 2 2018, Mabirizi versus Attorney General of Uganda, were in accordance with the Ugandan laws and Articles 6D and 7.2 of the treaty. My answer is yes, they had. My lords, this caters for grounds 3, sub-grounds 3 to 5 of the memorandum of appeal. And I'm going to argue them accordingly, starting with burden of proof. My lord, at paragraph 121 of the judgment, page 3206 to 3207, the court erroneously adopted a criminal-like burden of proof in the South African Court of Justice. Why? They said, in short, the respondent state would not be put to its defense in the absence of the demonstration of a prima facie case by the applicant. That's what they said at paragraph 121. Yet the rules of the court have no place for putting a state on defense after a prima facie case, thereby going against the burden of proof principles set by this appellate division in appeal number 1 of 2015, that is Union Trade Center versus Region of Rwanda. In that appeal, the court said that proof is essential unless the matter is admitted, or the burden of proving such matter is by law shifted to the adverse party. So in this case, there's no way the burden was shifted, but the lower court is saying that I had to prove a prima facie case. Then it's like it was saying that they have a choice not to respond, to keep quiet until when evidence has been adduced. That is in a criminal trial. My lords, when there's no actually doubt that this is a civil matter, I refer you to appeal number of 2012. That is Aringa General versus Omar Award. This court said that at paragraph 37 that we should never say that the cause of action for a reference now before this court is a matter of civil law. So for you,
Mr. Mabirizi, when the law says for you to get an injunction first injunction, you must make out the prima facie case. Does that mean it's a criminal matter?
No, but the perspective is different.
So you can actually have in civil matters a situation where you still have to make a prima facie case before you can get some relief.
But when you say that this person should, the respondent set would not be put to its defense. When you say the respondent set would not be put to its defense in absence of demonstration of prima facie case by the applicant, this is dangerous because the respondent puts in a defense within 45 days.
So you take being put on your defense to be like in a criminal defense, like in a criminal court?
This is the context this lower court was adopting.
Okay.
And I understood their background, but it was erroneous. They were relying on foreign decisions. For example, of Bosnia and Herzegovina versus Serbia and Montenegro, and USA versus United Mexico States. Now, they erroneously relied on this because first, the case before the court here was not an interstate conflict, but a case by a resident against the state. Two, the word charges, they were using the word charges in those cases. In Bosnia case, it's clear that the standard mentioned there involve criminal actions. When a state aggresses on another state and involves criminal actions. So these judges transplanted the jurisprudence in interstate criminal conflicts into this civil matter. That's the point I'm making. And when you look at Black's Dictionary 8th edition, at page 701, a charge is called a formal accusation of an offense as a preliminary step to prosecution. So the ICJ in Bosnia, they met the criminal elements in the aggressions. So this lower court misapplied that. My lords, when you actually look at page 2330 to 2331, I submitted how the respondent in the lower court did not file any affidavit in a specific reply to paragraphs 4 to 118 of my affidavit. So some of these things were not actually rebutted. The facts were not rebutted. But the lower court is saying that they did not need to put their defense. Yet actually in civil, when you don't respond, you are deemed to have admitted. Then there was a reliance, my lord, on when you go to paragraph 122 of the judgment, the judges relied on rule 66 of the rules of the court on burden of proof that I failed to summon witnesses. Yet actually, in this case, there was no need to summon witnesses, since all was required were documents in the opposition of the respondent. The lower court, at paragraph 123, again made another abnormal finding. That for purpose of standard of proof in the present case, the standard of proof, it is that
Abnormal or erroneous?
it goes beyond erroneous. It is so abnormal, in my opinion, because the judges are saying, for purpose of standard of proof in the present case, is that the fully conclusive evidence required of challenges of apex court judicial decisions should demonstrate a clear and notorious injustice, visible to put it thus a mere glance. And at page 32, paragraph 249, they said, the reasons underlying the majority justice decisions and or indeed the decisions themselves cannot be suggested to depict a clear and notorious injustice that is visible at a mere glance. This is the standard of proof they are putting in a civil matter, where the treaty only says, just prove there was unlawfulness, there was breach of the treaty. The court is saying, I must demonstrate something, I don't know, fully conclusive evidence. This was a standard which is not applicable to this matter. And wherever they picked it from, the facts were actually different. Those things involved actually, the court contradicted this decision in application number 9 2018. That is Basagi Abalaba and another. At paragraph 3 of that decision, the law first division said that the decisions or actions of the domestic courts may be interrogated to determine their compliance with express provisions of the treaty. Now, this is the standard. We interrogate the compliance. Now, in my case, they change. They take the Supreme Court of Uganda, they give it a little higher rank, that for it to be interrogated, I need something higher than, for example, if I'm interrogating the actions of the police of Uganda Revenue Authority. Yet actually all organs are equal international law. I can impute their conduct. My lords, you look at I had discussed when my time was reduced from 4 to 10 minutes in Supreme Court. The land judges upheld that without any serious reasoning. Because what is the rule of land fairness? If you agree, we agree. You don't come then disadvantage me. Then, the lower court confused my December 2020 recuse application because somewhere it said that I did not raise the objections against the judges in the lower court. That's why they said I should keep quiet for permanently. But now they... 10 minutes.
Yes, 10 minutes.
Thank you. I will first rejoin to Mr. Martin Mwambusha. First, my lords, I listed 11 aspects which were pleaded, argued, and decided upon by the Supreme Court of Uganda. They're not out of time because the Supreme Court made decisions which I was challenging. Mr. Martin has not provided specifically how those matters were answered by the court. So you cannot make a general statement that they were answered. Yet I was specific on each and every aspect, where it was, how it was argued. There is no answer. On going to my conduct, my lord, there's always a scheduling conference. We held a scheduling conference. We never raised any issue relating to my character. We never argued it. Yes, they could have made some general things, but now, my lords, if someone says the applicant is habitual an abuse of court process, that follow within the jurisdiction of the court within the 60 days. If I appeared with them in 2019 in another case in Kampala, and then they said that guy is an habitual court abuser, can this court come today and say, yes, we have also found this is an abuse of court process? This is something which, lastly, on Mr. Mwambusha, my lords, I will refer you to the case of Charles Ojango Bo, President General of Uganda. It's Supreme Court Appeal number of 2002. The Supreme Court was clear that a court has no liberty to disregard decisions. You analyze them and say, I disagree. But you don't just combine everything and say, I have not found any merit. That not of a court of record. It goes to now, let me go to Mr. Adore on time. My lords, the facts of a complaint are not for jurisprudential background. What do I mean? I sued the Supreme Court decision. Which Supreme Court decision had facts leading to it. Those facts, you cannot just say these are jurisprudential backgrounds. Those are the facts which form part of the cause of action. That's where the journey began. You cannot say I'm not looking at this simply because jurisprudential. How? Because here we are dealing with facts. These are not, jurisprudence. Lastly, to Mr. Second last. The case of Semogere and the issue raised by my lord on your right. My lords, under the Ugandan law, there is nothing like presumed validity of an act of parliament. The Ugandan constitution provides under Article 137 that after parliament has passed an act, that act can be challenged. And the burden is on government to prove that actually the act complied. So there is nothing like presumption. Actually, they have to bring evidence. And again, there is yes. So when I challenge, the same question says it shall come in force, but says it can be nullified by the Constitutional Court. So just Cunningham by saying, since the same constitution, yes, my lord.
Sir, Mr. Bagisu, the question is, What is the status of that law before the court where it's challenged pronounces itself?
It's a hanging law. Yes, as per the Somobere case. And my lord, that was a constitutional interpretation. The Supreme Court interpreted the Constitution of Uganda to mean that a challenged law is a hanging law. It hangs in balance. I will now move on to Mr. Madete. My lord, proof. They say I needed cogent evidence. That submission is defeating the decision of this court in Union Trade Center, which say that evidence can be by affidavit. When I swear on oath, and I say so and so studied with this person, that is evidence which they never rebutted. These judges never rebutted this evidence. And I don't know which more evidence they need me to bring. Their birth certificates what? So there was evidence before the court. Again, the thing of Apex Court defeats Articles 6, D and 7 too. Because it's like they want to create the Supreme Court of Uganda as a different organ of state. Yet here, countries come in equal measure. Whether an action was by police, by veterinary officer, by magistrate, they are all decisions of the partner state. So we cannot give them. As a governor, they are saying that it's a civil court. It's an international court of justice. But the facts there constituted criminal actions by a state. When a state does aggression on another, there are some crime acts which are done. That's what it was in Herzegovina. Minor solution submissions in Supreme Court. Both parties agreed that we file written and we argue. We agreed that I would wait 40 minutes. That was reduced. I get no answer. Now, on the incompetence of the judges, my lord, I call upon you to look at paragraph 205 of my writing support at page 96. I said, these facts came to me after judgment. My earlier refusal was on the facts which were known, and we sorted them out. These facts came after judgment, and this is my evidence. So it's not clear, it's not good to say that you once raised it and I abandoned something different from what was here. Then the instruction fee thing, the Advocates Act does not apply to me. So why was it used against me, and why was the court saying a law should be made against me as if that was also an issue? You see, this is a matter of court moving around. Lastly, who won judicial fraud? I call upon you to look at the judgments of the Supreme Court of Uganda. There was issue number, is it 3 or 4? Or substantiality test. I won 4 judges. 4. Katwebe, Chief Justice, Arachi Amoko, Professor Chirukubinza, and Mangusha. They all said that ground succeeds. In the final verdict, the Chief Justice is saying, I am losing by 4-3. Yet I won by 4-3. And I was saying to the court, look, this was a breach of the treaty. They are saying go back to Kampala, which cannot. Finally, on remedies. My lord, there is a manifesto of miscarriage of justice. Therefore, by the case of Double a pre-trial, a de novo hearing is determined, is merited. Then you have the powers as an appellate court to determine undetermined matters, because you have the evidence. Damages, I pleaded damages in my memorandum of appeal. I don't know why she's saying that I never pleaded it. It's pleaded in the memorandum of appeal. Actually, I've been looking at it here on the orders, and I pleaded for damages. And they are muted because this is some general damages.
For damages, one matter public interest.
My lord, it's public interest, but I've shown more interest than other Ugandans. That's why I'm here. My lords, I return my prayers.
So where does public interest end and Mabirizi's interest start?
Mabirizi is a member of the public. Is an East African as other.
So it limits the public interest to personal interest.
No. The damages are for personal inconveniences, suffering. Because when government breaches the law, every person is inconvenienced. But specifically, Mabirizi comes out and photocopies and prints. That's why the damages. And there's a decision of the Supreme Court of Uganda, I think Mwanga Chivumbi, where they're saying, yes, some matters can be public interest, but these litigants who come out to be civically active need to be awarded for their activities. including damages. Yes, costs, but in this case, including that, because down the inconvenience, I travel by bus to come here, go back, this and this, because
Those are costs that we are just talking about damages.
I may not get the cost of appearance because I appear for myself. So I
But in terms of damages, what damage have you suffered over and above the ordinary factors?
trauma and inconvenience. It's really the case.
That's why you're being very costs. Reversing what you suffered.
My lords, you look at my authorities on damages. My lords, first of all, I need to regret the delay in last week in this appeal. I was imprisoned, so I couldn't access these documents to come and argue. That's why it had to take this long. But we are finally here, and thank you for your patience.
Mr. Mabirizi, thank you for highlighting your submission. Thank you for all this, for your public interest. Councillors, thank you. And this marks the end of this hearing. Judgment will be noticed.
Please rise.